Welcome to our 5-minute takeaway sessions presented by the Guild of Letting and Management. My name is Susie Crolla. I'm Managing Director of the Guild of Letting and Management. In this takeaway session, we'll be looking at what the removal of Section 21 means for landlords under the Renters' Rights Bill. So the Renters' Rights Bill is currently progressing through Parliament and proposes the abolition of Section 21 of the Housing Act 1988. A change which marks one of the most significant reforms to the private rented sector in over 30 years. Now, at present, landlords can serve notice on tenants without actually providing a reason, provided that the correct notice is served and that all statutory requirements are met. This is often referred to as a no-fault eviction. Now, the government has committed to abolishing Section 21 and with the stated aim of providing tenants with a much greater sense of security and stability in their homes. So let's think about the key changes and implications for landlords. What does this end to no-fault eviction mean? So landlords will no longer actually be able to end a tenancy solely by giving 2 months' notice under Section 21. Bringing a tenancy to an end will only be lawful if valid grounds under Section 8 of the Housing Act 88 are established and evidenced. So this therefore restricts a landlord's ability to regain possession of their property unless very clear, specific criteria are met. So we need to think about the reform and expansion of Section 8 grounds. To compensate for the loss of Section 21, the government intends to reform Section 8 as follows. There will be new mandatory ground allowing landlords to seek possession if they intend to sell their property. There will be an additional mandatory ground if the landlord or a family member wishes to move back into the property. One of those most significant amendments sits around Ground 8. Ground 8 is the mandatory ground for possession if a tenant is currently 2 monthly payments in arrears. In the future, the tenant will have to be 3 monthly payments in arrears for Section 8 under Ground 8 to be relied upon. There will be a new ground for antisocial behaviour, and this is extremely important because the landlords must be aware that reliance on all the grounds, discretionary and mandatory, will require evidence and most definitely in all cases will require a hearing. So let's think about the introduction of periodic tenancies. All assured short-hold tenancies will become open-ended periodic tenancies, meaning no more fixed-term contracts. Tenants will be able to serve notice at any time, and that will be 2 months' notice, which will offer them much greater flexibility. Now, this indicates that landlords will need to adapt their business models to accommodate less certainty over tenancy lengths. The next point to consider is the increased administrative and legal burdens. Landlords need to factor in the following. They will have to maintain accurate and up-to-date records to support any future possession claims. They need to ensure compliance with all legal obligations, for example, tenancy deposit protection, registering all properties, residential, on the private rented sector database, and of course ensuring that there is compliance with all safety certificates, as these may still form defences to possession claims. It's important for landlords to be aware that they need to be prepared for much higher increased scrutiny of processes and decision making. Now, one of the key elements that's been discussed is key reform and enforcement challenges. The success of these reforms relies heavily on the efficiency and the capacity of the court system. Landlords have expressed concern for a significant time frame about the delays in possession hearings and also the lack of fully digitalised and streamlined systems to support timely enforcement. And the government has promised to improve the court process before abolishing Section 21, but a clear time frame has not yet been published. So landlords need to think about the strategic considerations for them and their businesses. They're advised to familiarise themselves with revised Section 8 grounds and prepare for a more regulated possession process. They need to reassess tenancy agreements, policies and notice procedures that reflect the new legal framework. They need to consider the potential implications on cash flow, void periods if tenants depart on short notice, investment decisions, especially where regaining possession for sale or for personal use is necessary. And they really need to think about engaging with professional letting agents, solicitors firms and trade organisations to stay informed and compliant. In short, the removal of Section 21 represents a significant shift in the private rented sector. It's rebalancing the legal relationship between landlords and tenants. And whilst possession will still be possible, it will require specific lawful grounds, supporting evidence, and place a much greater emphasis on professionalism, compliance, and robust documentation. So think about those elements carefully, and we look forward to seeing you on our next session. Thank you for listening to today's session. For further information on the services we offer, head over to our website and subscribe to our channel. I look forward to seeing you next time.